Welcome back to the Texas Appellate Law Podcast. I'm Jody Sanders.
And I'm Todd Smith.
And our guest today is Andrew Gould of Arnold Itkin in Houston. Andrew, thanks for joining us.
Thanks for having me. It's really an honor to be with the both of you, after 5 years doing this podcast. It's really impressive. I listened to your last episode with Milo and him talking about kind of the service that you all do through this podcast in terms of the tips. And I'm sure we'll talk about it with this conversation, but I've been listening ever since I moved over into the Texas civil appellate world. And this podcast, has been a must listen for me just because of all the useful tidbits I would get out of it. I'm a little daunted by the fact that you all have asked me to do it because I don't know what tidbits I can share with the listeners, but I'm grateful to be here.
Well, we appreciate it. And we did not actually ask him to do that. He's not being compensated. So,
That's
we
two
really
episodes in a row.
That's right.
We've had,
I know.
kind of a rah-rah talk at the beginning. Hey, we'll take it. But
Absolutely.
yes, we promise our audience we didn't put these guys up to.
Well, Andrew, for our listeners, I guess just tell us a little bit about yourself, kind of your background and how you ended up in the law and where you are now.
Sure. So I guess maybe we'll start from the beginning. I was born and raised in Louisville, Kentucky. And the first thing I ever remember wanting to be when I was 5 years old was an NBA player. I quickly realized as a Jewish boy that was probably not going to be my future. That morphed into I wanted to be a sports announcer. And then I guess real life took over. And in high school, I started thinking, maybe I should go into the law instead. I like to read. I like to write. I like to debate. This seems natural. And so I kind of got the law school bug, I would say, in high school. And so when I went to college, I left Louisville. I went to the University of Michigan in Ann Arbor for college. And I knew pretty early on, I was like, I'm going to go to law school. One of the questions, though, for me was whether I was going to take any time off between law school, between undergrad and law school. And if I was going to do it, it was going to be in politics. I worked for Senator Mitch McConnell of Kentucky. He was then the majority whip of the Senate, and just as an intern, right? Just as a summer intern. It was a great job. Great exposure, that summer to just all these leaders and, great people on Capitol Hill. And afterward, that was my going into my junior into my senior year. And there were conversations. There was going to be an opening for a legislative correspondent role on his DC staff. And they were asking me if I would be interested. And I ended up saying no because I was just impatient. I really knew I wanted to go to law school. I'm not sure whether that was the best decision, but that was the decision I made at the time. And so I headed from Michigan to Vanderbilt Law and spent 3 great years there. And it was there that I started thinking about a career in appellate litigation. I don't have any family members who are lawyers. And so I knew I didn't want to be a transactional lawyer. I wanted to be a litigator, but I didn't know the difference between a trial lawyer and appellate lawyer. I thought if you were going to be a litigator, you were going to be Jack McCoy from Law and Order. And that's who I wanted to be. Again, like so many things, that did not turn out to be the case. So, but that's what I knew early on, right, that I wanted to go to law school. And I just, like I said, for better or worse, I just jumped straight in.
You mentioned getting introduced to appellate law in law school. I really wasn't. I'm curious, what were you exposed to? Kind of what got you interested in appellate law during law school?
I think it was a couple things, Jody. It was first some of my professors who before joining the academy, when they were in private practice, they were on doing appellate litigation at their respective big law firms. So there was that side of it that I learned about. And also it was kind of just the process of what you do in day-to-day life as a law student, at least at my school. I'm reading cases, I'm analyzing them, and then you go to class and you're talking about their meaning, and what the law is. You're not talking about the facts.
Yep.
I'm not sure, what Vandy law is like right now, but it certainly didn't teach me to be a trial lawyer. We did have trial advocacy courses. And so I had that one side of it. And then also, I think when I went to the Justice Department in between my first and second years of law school, and I was in the Office of Legal Policy, which is not a litigating department of DOJ. It is a policy shop. But even then, they are more thinking about the law. And some of the people there were coming from appellate backgrounds. In fact, the person who hired me is now on the Ninth Circuit, Judge Bumate. I remember interviewing with him. He was probably in his early 30s at the time. And so, I got exposed to that side of it, or appellate litigation, from people I interacted with. But I will say, and, we can, probably dovetail with the U.S. Attorney's Office conversation. When I was at the Office of Legal Policy, there were a number of attorneys who were there who were on detail. They're just like 1 year. They just needed extra help. And so they were assistant U.S. attorneys. They were trial prosecutors. And I remember I would go out to lunch and drinks with them, and they would always be pushing me there. They would say, Andrew, you need to be an AUSA, one day. And I remember thinking, I'm like, I would nod politely and say, oh, that'd be great. I had zero interest in it at the time. And, life has a funny way of changing. But it really was, like I said, in law school, it wasn't like I had like an appellate advocacy class, although I did take, there was an appellate litigation clinic that I did take either my second or third year of law school. But I think it really was through the professors who that was what they did when they were practicing lawyers.
Well, you mentioned the AUSA experience. It sounds like that pep talk you got from the people that were on loan, that it worked. You went into the AUSA's office. Tell us about that experience.
So it was fabulous. It's an amazing job. So what happened, Todd, was after I clerked for 2 judges after law school. And then I went to Gibson, Dunn & Crutcher in Washington, D.C., where I had been a summer associate. And when I was at Gibson Dunn, I was fully in the litigation department. They have what's known as a free market system, in that the associate, you were assigned to a department. You were in litigation, you were in transactional, or you were in tax, at least at the time. But beyond that, it was all on the associate to go find the work. And which was attractive to me. And one of the reasons I picked Gibson Dunn at the time was because, and it still has, a really strong appellate group. And I was able to split where I was doing half of my time in the appellate practice group. And then I did 50% just general commercial litigation on the trial side. And it was more to kind of test the assumption that I had, coming out of law school, even coming out of my clerkships. Do I want to be a trial lawyer, or do I want to be an appellate lawyer? And I'm not trying to go out of order, but I clerked first for a federal appellate judge. And then the year after that, I clerked for a federal district judge. And that was intentional. I wanted to see what life was like on the trial bench. And again, part of it, it's a great learning experience, but just to learn, I didn't learn what being a trial lawyer was like in law school. And so at Gibson, I was there for about a year, a little under 2 years. And what happened, it was just unintentional. It was a great place to practice law. And it still was. I saw many friends who practice there. They now have a Houston office. They didn't at the time. They just had the Dallas office when I left in 2014. So what happened was, I met my now wife the year I was clerking for Judge Lee Rosenthal in Houston. And my wife was working for Rice University in their HR department. I convinced her to move with me to DC and succeeded. And she went to George Washington University in their HR department. I want to say it was within a month or two of us getting to DC. Her boss at Rice had left for a different position, and they started recruiting Becca very heavily to come back. Well, we had just gotten to DC. And so she just were like, the timing's not right. And so she politely turned it down. So a year passes and Rice hires somebody else for this position. It does not work out with that person. And they come back to Becca. Becca is really, really, really good at what she does. Very good. And so they started recruiting her very heavily to come back. And now at this time, I had had about a year within Gibson Dunn and seeing what it was like. I had also realized I did want to focus exclusively on appellate litigation. I loved the trial lawyers I worked with at Gibson. They're great people, but I was too much of a nerd. I wanted to just focus on just appellate litigation, but I was happy at Gibson. So I was very happy at Gibson Dunn at the time. And so when Becca got approached the second go around, I said, well, there's no other law firm I want to go to in Houston, which is, actually very short-sighted. I mean, there are some amazing law firms, big and small, in this city that I've only, come to realize. You would have thought that I would have gained that knowledge after a year clerking, but it, really didn't process at the time. But I wasn't interested in going to any other law firm because I was happy at Gibson. And at the time, there had been a long-standing hiring freeze at the Justice Department. I think it all really stemmed from the 2008 recession. And President Obama finally lifted it in around 2014. And so all of a sudden, a spot opened up in the appellate division of the U.S. Attorney's Office in Houston. And I realized, I said, this is going to be a way, this is the type of position where I knew from the people I'd interacted with at OLP, the AUSAs who were on detail, how much experience you get and responsibility early on as an AUSA. And I just thought, my goodness, like this would be such a great opportunity. At the same time, again, it was a situation in which they had just opened up, this one position after all these years. And I remember seeing there's like, I cannot imagine what the candidate pool is going to be like. But I said, that's what I'm interested in. So I said, I will throw my hat in the ring for this. I will pull out all the stops I can do and try to make this happen. And it's, oh my gosh, it's still my favorite interview story. At the time, when I was at the U.S. Attorney's Office, most of the people who they hired in the Southern District of Texas are former prosecutors, whether they're coming from the Harris County DA's office or another state DA's office. They didn't, at least on the criminal side, hire a lot of people who did not have prosecutorial background. I had none. Right? Like all I had were my 2 clerkships and what I learned, but I made some friends during my year clerking for Judge Rosenthal who were AUSAs, and they encouraged me to apply. And they gave me and they told me kind of what I should be thinking about for my interview. And they told me, they said, really one of the things they're going to be asking you a lot about is your experience. And so I come into the interview. It was actually coincidentally, I got called for an interview the same day that my wife had her token interview at Rice. So we flew on separate planes to Houston. She's doing her interview. I do my interview. And it's, so I go in and it's a panel interview of the first assistant U.S. attorney, the 2 executive AUSAs, the chief of the appellate division, and the deputy chief of the appellate division. And for 1 hour, it was basically 1 hour of variations of how the heck are you qualified to do this job? And so I remember answering that in as many different ways as possible. I walk out of the interview, fly back to DC. Again, my wife and I are on different planes just because this is coincidental. But so I call her from the airport. She's in her token interview and I leave her a voicemail. I said, Becca, just got out. It went great. I'm really happy with how I answered the questions. I am not getting this job. They're looking for somebody else. And so and what happened was they actually ended up hiring one of my former colleagues, Anna Kaluri, who came from the Boston DA's office. She's a fantastic appellate attorney. And it was absolutely the right decision. I didn't know that at the time, right? I just knew that I didn't get it. But they made the right decision. And then they made another good decision later. So I don't
apparently.
Becca, I'm sorry that this is turning into a conversation about my wife, but it is part of my story.
Hey,
Becca
No
turns
worries.
down the job at Rice because I don't get it and I'm stubborn. And I said, well, this was the only thing that I was interested in. So she turns it down. About 2 to 3 weeks pass, and I get a call from the first assistant U.S. attorney. And he says, Andrew, we found more money in our budget. We'd like to offer you a position. And I was just like, Abe, thank you so much. Like, I'm so honored. I don't know if I can say yes because my wife just turned down this, this position. And so he said, well, talk to your wife and, get back to me. So I, hang up and I call Becca frantically. And I'm like, Becca, you're not going to believe what happened. I explained it. So she gets on the
Timing.
phone, calls Rice and tells Rice, this is what happened. And they're like, we haven't hired anybody. The job is yours. So, the stars aligned in terms of that. Anyways, that turned into a really personal story. The professional side of it was really, what drew me to the job were a couple of things. It was the experience that I could get very early on that you just can't replicate at a law firm, at a private law firm. You just can't. And then there's also, there is a public service side bent that I have, which was, how neat would it be to be in public service? I got to stand up for 7 years and start my oral arguments with Andrew Gould for the United States. And
Pretty
that's
cool.
just really, it's really special. And you joke about it or people joke about it, but it's the only department that's, formed on an ideal. And so, I really did believe was to go out and do justice every day. And if that meant that I needed to make a concession to a criminal defendant, I did it, or I at least recommended it. So I'm sorry, I really went far. I'm sure.
No.
That's what we love, though. We love
Don't be
those
sorry.
stories because
Yeah.
that's the interesting part. I'm curious, you coming from Gibson Dunn, working in the litigation department, how was the transition to doing criminal appellate in the Fifth Circuit?
Tough, because I didn't know anything. I knew how to research and I knew how to write, but I, even in the appellate department there, I was, kind of writing portions of briefs and they were being very heavily edited by the partner for good reason. And then it turns into, instead, you show up on day one, you take your oath of office and you have these pile of cases and they're yours. And that's not to say that, obviously that like I'm by myself. The doors are all shut. I can't talk to anybody. There's a review process and everything. But it was like, here are your appeals and start working on the briefs. And, this was an area of law, criminal law. The only time I had touched it was when I was a law clerk and the mandatory criminal law course I took in law school. And that was it. Because I never had any intention of being a criminal prosecutor. And so it was just a giant learning curve in terms of the law, the federal rules of appellate procedure, this circuit practice, and then just the nuts and bolts of writing a brief and being responsible for, from soup to nuts. There is no better way to learn. There just isn't. And the experience that and the job was everything I could have hoped for and more. I just gained so much experience very, very quickly because I was just thrown in the fire. And that is really, I think that when you talk to other AUSAs or assistant district attorneys or public defenders, they all say the same thing. And so it was a tough experience with a tough learning curve, but very well worth it.
As an appellate prosecutor at the U.S. Attorney's Office, is it just sort of compartmentalized, like you literally do appeals, or did you get kind of called in for trial work, sort of like you do on the civil side? How does that work?
That's a great question. So we, at the Southern District of Texas, with the caveat of I haven't been there in some years, so I don't know if it's changed. It was predominantly, 90% it's called 80% of my work were direct criminal appeals in the Fifth Circuit. 10% of my work were habeas petitions, or I guess they're technically motions for post-conviction relief under 28 USC 2255. And then the remaining 10% was trial assistance. We, in our division, were assigned certain trial groups to kind of be on call for if they had a question, if they needed legal assistance. I love that. I loved working with the trial AUSAs. I mean, first to just kind of break up the monotony of just,
Yeah.
briefing sentencing issues again and again. And they're important, but, again, just doing something different, but working with great line prosecutors and learning about what they do and seeing really how the sausage gets made, which is so, so important for an appellate lawyer. Meaning, it is one thing to read a cold record and to look at it and to just say, like, how the heck did this trial lawyer, make this mistake?
Mm.
Once you're in there, right, and you watch it happen
Yep.
live, you start to understand more. I mean, it doesn't make it necessarily less frustrating, but you gain more empathy. But I mean, it was a very serious case, but one of the most important cases I worked on I forget the exact, it was a armored car robbery trial. And I got a call after the verdict, which was a guilty verdict, and a motion for a new trial had been filed accusing the lead case agent of lying on the stand. It's a very, very serious accusation, as you can imagine. And it was based on kind of a conversation that the case agent had with the defense attorney while waiting for the verdict. It was a misunderstanding. It was a joke that went really, really bad. And it was inappropriate. I actually said that in my Fifth Circuit argument when it later came up. But I remember getting the call about this, and they just said, this is going to be the issue on appeal. We'd like to bring you in now to start working on it. And so I worked on it with them in terms of crafting the response, getting ready for the motion and evidentiary hearing, with the agent testifying. And then, that let, the judge denied their motion. And then that was the big issue up on appeal. And so I really, really valued working with the trial AUSAs. I learned so much from it. And I did, in fact, I even tried a case once just because I wanted to. I wanted that experience.
Yeah.
I went to Corpus and I just said, find me a more straightforward case that I can just kind of parachute into, and with somebody who's willing to work with somebody who has no clue what they're doing, and let me come in. And they found a 2-day trial. And I got to experience that. And that was a special moment too.
That's cool.
I don't want to let it go without confirming your circuit clerkship. You mentioned having clerk for Judge Rosenthal, and you mentioned also doing it in different order than what most people do. If they do 2 clerkships, usually it's a district and then a circuit. Who did you clerk for in the circuit court?
I clerked for Judge Ray Kethledge on the Sixth Circuit. Judge Kethledge is in Ann Arbor, Michigan. And so when I was really fortunate to have 2 amazing clerkships, and I try to help law students who are looking for clerkships and try to guide them through the process. And though one big thing I tell them is that it's not a true meritocracy. You are, depending on the clerkships, right, there is a certain academic threshold, right, that each judge has. And that's true. I mean, that's true whether we're talking we're talking federal circuit court, federal district, clerk, Supreme Court of Texas. There's always going to be this one threshold, but there are a lot of people who pass that threshold, right? So maybe you're getting from 200 applications to 50. Now, how do you, the judge is not going to interview 50 people, right? I don't know of anybody who does. So how do they decide who to interview? I'm sure some of them do it strictly just based on looking at, the resume and seeing it. But a lot of times it's, well, I happen to know this reference, right? And let me give them a call, ask them about this student, because, judicial chambers are very close quarters, and you have one bad lake in there. I mean, that can throw off the entire year. I'm fortunate that didn't happen, at least not that I've been told, in my 2 years. So how I got hooked up, and so it was connections that helped me with both of my clerkships. So for Judge Kethledge, I like to joke, he was a baby judge when I was with him. He was entering his 3rd year on the bench when I started with him. There is absolutely no way I'd be hired by him today. I've told him that. He's politely said that's not true. I disagree. But he had gone through the confirmation process when with my boss at the Office of Legal Policy. And she said, I think you'd be a good match for him. You really like writing and you went to Michigan, and he's in Ann Arbor and he's a double Michigan guy. And I remember thinking, I don't really care how good of a writer he is. I get to go back to Ann Arbor for a year. And so sign me up for that. And it turned out to be an unbelievable clerkship year. It actually fundamentally changed me as a writer. I thought I came in as a pretty good writer. Judge Kethledge really changed my writing style. He is just a fabulous, fabulous writer. But what happened was when I was going through the clerkship application process, it was like I don't know how it works now in terms of the system, right? And when applications open and when they can call you for interviews and everything. It was still kind of working okay at the time in terms of this was, when judges could call you. So I'd applied I'd been told by my clerkship advisor, we think you'll be competitive for circuit clerkships based on your resume, especially in the Sixth Circuit, because you're from Kentucky, you went to Michigan for college, now you're in Tennessee for law school. So you're probably going to have a lot of interest from Sixth Circuit judges, which would, that being true. But I also applied to a number of federal district judges in major metropolitan cities, including Houston, as well as my hometown of Louisville. And so I, just blanketed the nation. I just, because I had no clue of who was going to be potentially interested in me. Judge Kethledge kind of jumped the gun a bit. He called me, I don't know, it was probably a week or so before I guess he was supposed to, but that was okay. And asked me to come and interview with him. And I was like, great. Again, I get to go to Ann Arbor. I'm going to do that. And, the interview went very well. He offered me the position. I was thrilled to accept. And so the day that I interviewed with him was the day that if the judges were following the rules, and sorry, Judge Kethledge, for identifying you as a rule breaker. But that was the day that they could actually start calling you. And so I get out and I received emails, from emails and some calls from judges asking me to schedule. And so I was like, what do I do? Well, with the circuit clerkships, I know that clerking for 2 circuit judges is now becoming more commonplace among some law students. I had zero interest in that. And so I just politely, turned down all of those. But the federal district clerkships, one of my mentors at Vandy Law and now a good friend, Professor Brian Fitzpatrick. So Professor Fitzpatrick clerked for Judge O'Scanlan on the Ninth Circuit and then for Justice Scalia on the U.S. Supreme Court. And I remember Professor Fitzpatrick saying in one class, I'm not sure how it came up, he said, the one regret I have is that I didn't clerk on the federal district court level. I think that would have been really interesting. I knew there was no chance that I was going to the U.S. Supreme Court. I thought maybe I like clerking at the federal district court level sounds really interesting. So for some of these judges, including Judge Rosenthal, I responded and I said, I'm very sorry. I've accepted a position for 2010, 2011. But I'm thinking I'd be interested in clerking, still interested in clerking for you. Would you be willing to consider my application for 2011, 2012? And I understand if, you have to say no. And they were open to it. And so, that was kind of, and so like that led into an interview with Judge Rosenthal for the year after. But they're different. They're different positions as a law clerk. I mean, at the end of the day, whether you're no matter who you're clerking for, again, whether it's for a federal appellate judge, a federal trial judge, a state appellate judge, you're interpreting the law, and you're helping the judge with draft opinions. But it is one thing to be on a multi-member panel, right? To be part of that.
Yeah.
With less volume than, working as a federal trial judge in one of the busiest districts in all of America. So it was really, in many ways, Judge Rosenthal wrote an email to Judge Kethledge at the beginning of my clerkship saying something like, Dear Judge Kethledge, thank you for taking Andrew on for this training clerkship. So, and in many ways, like really, it helped. Like I know most people go district and then circuit. I just cannot imagine it because really the training I got during the circuit level, it actually, I thought, translated well to handling the faster pace of the district clerkship.
Interesting.
Yeah. So I appreciate you covering that for us. And it's, the career path you've taken is you've had some unusual detours, I guess I would say, in some ways to get where you've gotten. But let's get into your transition out of the U.S. Attorney's Office and into your current firm.
Sure. So when I went to the U.S. Attorney's Office, again, I had no intention of being a federal criminal prosecutor originally. And it's a great job, but I always thought that there was going to be a shelf life for me, that at a time that I would want to go back into private practice. But I didn't know when that was. I remember, and again, I'll call him out. I remember Judge Kethledge telling me at the beginning that I started, him telling me that I really needed to think about after 5 years, whether I wanted to stay or go. And I just remember telling him, I don't think that that's right. I'll leave when I'm ready to leave, right? When it feels natural and not a moment sooner. But over time, as I continued to gain experience at the U.S. Attorney's Office and get all these great opportunities, I did start to get the itch of I wanted to try something else. I wanted to go back into private practice. But when I call it my Rubicon crossing moment of when I decided I definitely I was going to leave. It was not if, it was a matter of when. But I intentionally did it at a time, I had that moment when I was still happy in my job, right? In the sense of I was still fulfilled. I still enjoyed it. I just knew that it was starting to get time for me to leave, but I wanted to build myself a really long runway so that it wasn't as if I needed to just take the first thing that was offered to me, because I feel like that would just lead to bad decision making. I wanted to go when I was still happy at my current job because it was an opportunity I felt that I couldn't pass up. And so, you've had a number of guests over the years talk about how amazing the Texas Appellate Bar is. And I can attest to that. This was during the COVID, during the thick of COVID. And it was all by phone because people weren't meeting in person at the time. I spoke with probably, 30 different appellate lawyers, some nationally that I knew, but predominantly through the Texas Appellate Bar. Some of whom I knew, some of whom I didn't know. That they were just, people recommended that I talk to them. And I had all these conversations, and I had this big legal pad that I would take notes on of these conversations. And my question to them was, I think I want to leave at some point. What should I be looking for in terms of making this jump? And, I just got great advice from so many different people. And some of that led to natural, conversations about, maybe we might have a place for you here. But that's not how my current job turned out. So as this process is going on, I get a call from a legal recruiter. And this legal recruiter says, hi, I received your name from a friend who's a judge. You fit the profile of what this firm is looking for in its search, and I'd like to talk to you. And they identified the firm as Arnold Itkin. And I knew a little bit about Arnold Itkin at the time. This is, the holidays of, I guess, 2020. But I'm like, they're a plaintiff's firm that focuses on personal injury and wrongful death. And they're looking for an appellate lawyer, to start an appellate practice. This doesn't make any sense to me, because it's not that appellate lawyers were new. It's just, I'd never heard of this existing. But I always tell young lawyers, don't turn down a conversation. So I said, well, that's when I tell young lawyers, then I need to follow it myself. So I said, okay, I'll have a conversation with them. And I remember going into it just extremely skeptical, just being like, I don't think that this is this is just not where AUSAs go to after, leaving the office. But, you'll mention that I've had these detours and I've taken positions that I never really expected. And part of that is I think it's because I have a bit of an entrepreneurial streak in the sense of I'm willing to take risks and just kind of follow my gut. And when I met with them and we had conversations over a period of months, and just the prospect of coming in and, they said, we hire outside lawyers right now to handle the bulk of our appellate work, but we want to bring the vast majority of it in-house, and we want to create this practice. And we know nothing about it. We kind of want you to do it, or whoever they hire. I just thought that was so cool. I remember having, again, conversation. I said, I hope you're talking with other people, because this is a really big, decision you all are making too, in terms of kind of the firm infrastructure. It's not as if it's ever going to be, Arnold Itkin trial and appellate lawyers, but if you're taking all of your appellate work, or, 90+% of it, and bringing it all in-house, like, if it doesn't work out, like, that is going to be a huge problem. So like, I hope you're talking with other people besides me. But we just kept having these conversations, and it was just, and I talked to some people I trusted. I just said, I think they're going to offer me the position. And, what do you think? And it was interesting to hear the range of opinions. And there was a range of opinions about what I should do, because it really was considered at the time non-traditional. But I got to a point where I wasn't sleeping well at night, because I just thought this was too exciting of an opportunity. And I thought, I don't know whether it's going to work out or not. And I mean that not from their end, more from my end. I mean, I'm coming from a federal criminal appellate background to a all civil appellate background, predominantly in, state court, which I told them, I'm like, do you understand, kind of who you're hiring potentially? But it was just too exciting. I just said, I don't know if it will work or not, but what I do know is that I will regret it. If I say no, I will regret it forever. And so, they did offer me. I said yes, and now it's crazy. It's been 4 years, and since I joined, and we've gone from it was just me to now there's me. We have 2 other amazing appellate lawyers in our group, and an appellate assistant, and so it's it's not some major appellate department. I like to joke. I said, we're small. I think we're mighty. We'll let other people, I like to think we're mighty, but I don't know what others think of us. But it's just been, it's been great.
I mean, that's an impressive growth rate, just to go from 0 to 60 with you. And then now you've got 2 junior lawyer, or I assume they're junior to you.
They're, what, so they're, I mean, we don't really, at my law firm, there are only 2 partners, Kurt Arnold and Jason Itkin. There are no other partners. They're attorneys just like me. Both of them, I guess, are more, I would consider them, well, at this point, one who's been with me for almost the entire time, for 4 years, I would consider them both to be more like mid-levels, in the sense of Brian Christensen, who's in my group, who's fabulous. He came and he wasn't an appellate lawyer, but he had the pedigree and was interested in the job when it came up. And he has become an unbelievable appellate attorney. And then we added Parker Cragg to our firm he's approaching his 1-year anniversary. He was in an appellate group of a big law firm, and kind of made the move over here. It was intentional. I mean, Todd, I remember having conversations, with Kurt and Jason at the beginning of this. And I said, if you, based on what you're explaining to me about kind of the amount of work you have, if you want to do this right, it cannot just be me. Like it can't be. I mean, obviously at the beginning, it's only going to be me, but we're going to have to, add people. And so we all kind of agreed. It's like grow smart, right? So don't just hire somebody just to be hiring, hire the right person. And so because of that, we put a lot of stock in, for both Brian and Parker, they probably went through more interviews than they wanted to, but it's just to make sure to get the right fit, because it's been a long time, right, since I practiced in another firm's appellate department. But what I will say is, coming from Gibson Dunn's appellate department, which at the time, and I think it still is very large, You have all these associates and people coming in and people coming out year after year, as opposed to us. That turnover, you don't want that in your group. You
Yeah.
want people who, are going to stay, and obviously they might have better opportunities down the road and that they might need to take. But, it's finding the right people for your group is really important.
I think it says a lot about the firm that they were willing to invest the money and time into bringing someone in-house. I think it's fairly unusual. I know of a few other plaintiffs-oriented firms that have someone like you in there, maybe not even quite the size of a group like yours. I mean, 3 lawyers how many lawyers overall in the firm?
We have just under 30 lawyers.
Well, that's a good size firm. I mean, that's not a small practice. And so that kind of litigation orientation will, as I think we all agree, will spin off, a pretty good amount of appellate work. But it just, I think, says a lot that they saw the value in bringing someone with your credentials, although you had to relearn how to do the civil side of things and learn how to do, I guess, the state appellate court thing.
Just completely learn it. I mean, it was, I had, when I was at Gibson Dunn, all of my cases were in federal court. So I had never once appeared in any state court whatsoever until I joined Arnold Itkin. And learning the Texas rules of appellate procedure, Texas jury charge practice. And I say that learning as if it's almost past tense, like I've learned. Oh, no. I am still very much learning.
Yeah.
But, that first year, right, in terms of the transition, so much of it was process oriented, was just learning how things work in Texas state courts, both trial and appellate, because I am more comfortable in the Fifth Circuit and in federal district court because I say that's where I grew up I'm just, I sometimes hear lawyers say that they're nervous when they go to the Fifth Circuit, right? And they almost feel like it's more intimidating. And for me, I'm more at ease when I'm there because I feel like I know what I'm doing there. But it's, what I will say, and again, to go back to just how great the Texas appellate bar was, when it was just me and just at the very beginning, thankfully there were people, and I just remember I would pick up the phone and I would just say, I've got this issue. And I wouldn't reveal client confidences. I would just kind of describe them like, I've got this motion pending, what should I do? And people were always willing to give me assistance, and they still are, right? I still will pick up the phone and, call people. It's such a great bar that we have, and that I just feel incredibly fortunate to be a part of. It wasn't something I ever expected.
So now that you're at a firm that does primarily trial work, do you think that there's misunderstanding of trial lawyers about what appellate lawyers can or don't do? Or is it, I don't know. I mean, you've walked into a shop that didn't really have anyone doing appeals, and now you have someone. I'm just curious how the transition was and how you view each other.
Yeah, it was, I think it was interesting, right? Because, you come into a firm that has existed for, I think at the time, 16 or 17 years, and they had done very well for themselves in those 17 years. And then you have somebody come in and just say, on the appellate side of things, we've got to start doing things a bit differently, more in terms of just organizationally. I mean, more just like in terms of like the appellate side, but like, who is this guy? Right? Like who is this guy? And that is very fair. And so I worked very hard at the beginning to build the relationships with the trial lawyers. And one of the things that I've, and to make myself a resource to them and to be available, like not just on appeal, but at the trial level. In fact, when you view my practice, like our appellate group over time, whereas we started and just sheer statistically, we were just predominantly doing just work in courts of appeals or Supreme Court work. So just pure appellate work. And that percentage has come down to now it's close to 50-50. And that's by intention because, I just say, if we can help you build the record at trial, it will be so much better for appeal. Or frankly, if a case can be resolved before trial, and I'm not suggesting that in the sense of that people that any side, plaintiff or defense, should settle for 1 penny less than what they think the case is actually worth. So I don't want to be misconstrued about that. But I often tell lawyers, my trial lawyers, when I get a case, I'm like, if you give me this appeal, right, add 2 to 3 years in terms of how long it's going to go, because we're not just talking about the state intermediate court of appeals, but potentially the state Supreme Court. And there's just like that timing while you hear that and you say, oh my gosh, 2.5 to 3 years. But any appellate lawyer will tell you that's actually pretty normal.
Yeah.
And so when, especially for us, when we represent, injured plaintiffs, who a lot of them don't come from great financial means, like, this is important to them. And sometimes it's, can they wait 2.5 to 3 years?
Yeah.
You have to factor that into your decision making. And again, trust me, my docket is full of appeals. And so like, we're still taking plenty of cases all the way to trial and on appeal and everything. And sometimes that has to happen.
Sure.
But there has to be an informed conversation. But when I work with the trial lawyers, I like to give them what I call a menu of options. So when they come to me with a problem, and I basically say, it's like, you could do 1, 2, or 3, right? Most aggressive to least aggressive. Here are your chances. But you're the trial lawyer, right? You make the call. I mean, I can advise you. There are certain times when I tell them, no, you absolutely cannot do this. Right?
Which is an incredibly important part of our job.
Right. Like I just say, no, you can't, but less so than you would think, right? Because a lot of times I can say, well, I can make an argument. But it's just going to be, it's a tougher argument. But if you want to do that, this is what I can do. And I think having that open dialogue and the level of trust is just critical.
Yep.
And then also understanding that every trial lawyer is different in terms of their personalities. And so, working with all the different attorneys at my firm, and I joke, I say, I have the unique position of like, I get to work with everybody and I see what everybody's work style is like. And so kind of just understanding personalities and risk tolerance and also just a level of trust. And so you build that over time. But at the end of the day, what I always tell our trial lawyers is, it is, I think about, I have 2 clients. I have the actual client themselves, but I also have the trial lawyer who's the client. Because in many of our cases, the actual client is really just relying on the lawyers to do everything. They have no knowledge whatsoever of the process. And so they're just fully relying on the lawyers to make the best informed decisions. And so at the end of the day, I view it as, even when the case is on appeal, it's their case. So, kind of here the menu of options.
And Todd and I are both nodding our heads along with you. This is very familiar.
No disagreement here.
Yes, it's what do you want to do, and understanding it. What you don't want, right, is you don't want to, get a reversal in a case. I mean, you never want to get a reversal, but it happens. But you don't want it, and it's based on something that you haven't discussed ahead of time.
Yep.
I call it eyes wide open. Like that's what I always say, like eyes wide open. You go into it and we know exactly what we're getting into, what decision we're making, why we're making it. And so then we're okay at the end. If it doesn't come out this way, that's unfortunate, but at least we knew that was a possibility because we discussed it ahead of time.
I'm curious, particularly doing plaintiffs' work in Texas, kind of how is the makeup of the courts of appeals and how that has changed? How does that impact your strategy? Because you have clients, like you said, a lot of times that are injured, don't necessarily have financial resources, have to wait. But then you also have the, generally speaking, Texas appellate courts that are going to be less favorable to big verdicts and upholding big verdicts.
It's a reality, but it's not one that I can concern myself with. And I've had this conversation with Kurt Arnold and Jason Itkin about some of their biggest verdicts. Is I say, cannot control, I can't control. What I can control is the briefs. I can control the briefs. I can control, to a certain extent, my oral argument. Obviously, oral argument, the judges are asking me questions.
Yeah.
I can control that aspect. The other side of it, whether you want to view it as base politics, that's out of my control. And I just don't I don't care for it. It's, that was a big change, right? Coming from the federal system where everybody is appointed. Now you're appointed, but it's partisan appointments,
Sure.
but it's a lifetime appointment as opposed to partisan judicial elections that involve fundraising. And what I say is that's a system that people of Texas have chosen, and that's their right. But what I don't do, for example, is say, so, like in the Houston Courts of Appeals, it's no secret that there was a big turnover in this election of a lot of the democratically elected, or the Democrats who are judges were replaced by Republican judges.
Mm-hmm.
That has not affected my strategy at all. It cannot. Like, it just can't, because at the end of the day, what matters to me as an appellate lawyer are the law and the facts. Like and that's all it should be. Like, if our system is working correctly, and I have faith that it does, that's what should matter. People outside are free to talk about it and complain. I had one case I remember very early when I started where it was in the Supreme Court of Texas. We lost in a per curiam opinion, so I won't bury the lead. But
we've all been there. It's okay.
I was going to say, everybody raised their hand who's been subjected to that.
But it came from the Dallas Court of Appeals. And I forget where we were at the stage, whether it was the merits briefing or petition stage, but the other side wrote in their brief something like, because it was a split decision, and they expressly said something about, changed electoral circumstances led to this opinion. And I just thought, and I called him out. That was actually in my introduction, I just said, I just thought that was awful. It's insulting to the judges. It's insulting to our legal system. And I just thought, this is wrong. I cited the Texas Crit. I was like, this is, that's not the reason for this, right? We can disagree, right? We can disagree on the merits of the decision, right? Reasonable people can see things differently, but let's not say that. And so I get it. I understand it. I understand people talk about it. I will not allow it to affect my practice. I just won't.
I think that's the healthiest approach to take, because you'll drive yourself crazy if you start trying to factor in electoral politics into how you approach your cases. So I really like that approach a lot. I think it's a wise one. So we're kind of winding up on our time together today. I had a quick follow-up, and then we'll do our usual, kick it over to you for a tip or a war story. And I understand you have one for us, Andrew. So you're in kind of a unique position, having been recruited into a trial firm, a plaintiffs-oriented trial firm, which, as I think I've said, is very forward-looking on Arnold Itkin's part. What would you say to trial lawyers, particularly plaintiffs-oriented trial lawyers, who seem somewhat skeptical about working with appellate counsel? Because I've come across that many times in my career, and I think you're in a unique position to speak to that. So do you have any words of advice to those plaintiffs trial lawyers?
I think it's critical to have somebody as part of your team, and whether that's within the firm or you bring in somebody from the outside, right, as part of the team that can think about the next level of the case. And I just mean next level, like just appellate, right? What's going to happen with this on appeals? And again, to provide the best advice possible in terms of strategizing how the case looks, because again, that will shape the record. It will also shape decisions about whether or not you can achieve a pretrial resolution that all parties are acceptable with. I don't think for plaintiffs' lawyers, there is no doubt that it's an expense, whether it's in-house like my firm, or whether it's just a firm that's hiring outside counsel to come aboard. And you do have to be mindful of those costs. One thing I don't do is, when we have we're constantly in trial. I'm not at trial, all the time, and nor are my counterparts. We just, we know that it would be a good security blanket, but we just don't have the resources to just kind of sit there all during trial. And so what we do more is, I call it remote support, right? Which is, if something comes up, give us a call, email. We'll, if we need to run to a hearing, right? And that has happened in town or out of town, we'll go. obviously for jury charges, right now we do every single jury charge. And that's more on my insistence. Not that our trial lawyers aren't capable of doing it, but I tell them, I said, this is one thing I can take off your plate. So you can start thinking
Right.
about closing argument. And not worry about kind of, have I preserved the objection to this?
Preach it.
So it's an expense, but you can think about it again. I think for other plaintiffs' law firms, what you think about is how to do it in a way that makes sense for your firm in your particular case. Because some cases, they might just not have the value where you can afford to bring on an appellate lawyer, an appellate specialist. And that's understandable. But some of the big cases, are due. And whenever you can, it can help. But you also, again, I think you need to find the right person, because you don't want to, I think, what I never try to do, again, in my role, is I never try to change my trial lawyer's style or how they try a case. That is not, I don't view that as my role, nor am I good at it, frankly. Like, they know how to talk to juries. I don't. And so, but what I can give them is legal advice about, again, here are, things that you shouldn't, you want to avoid, right? Or, here are different things when you're thinking about this issue that's going to come up. These are, again, the different options that you have. And I think any appellate lawyer who's you bring on, again, whether it's in-house or hired outside, they'll be able to provide that. And then that, helps the case immensely, especially if it goes on appeal, because once the case is on appeal, the cake is baked, and we are stuck with that cake, however beautiful or ugly it looks.
Well, that's a good place to wrap up that commentary. The cake is baked. I love that. Well, so as you know, and just for the benefit of our listeners who don't, one of the things we like to do with our guests is to invite them to share a tip or a war story. So tell us what you got.
Yeah, there are probably too many, but this is one of my favorite war stories. So when I joined Arnold Itkin, we had we had just a crazy number of oral arguments my first year. And in several cases in which I parachuted into, I was not involved in the briefing whatsoever. And the briefing was not the way I would have done it. And I remember gearing up for a Fifth Circuit argument. And the brief wasn't the way I liked it. And I was doing case law, research, right? I was doing just to make sure we were up to date on cases. The good news was that we were up to date in terms of there were no new cases since briefing. The bad news was I found one case I thought was really, 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 really good for us, but it was really old that nobody had cited. And I'm just what do I do with this? So I had recalled from when I was at the U.S. Attorney's Office, at one point, I swear this existed, but the Fifth Circuit had on their homepage, they would occasionally post these notices. And there was one notice that was posted at some point in time. It's not there anymore, but it basically said, litigants are filing 28J letters, which are the supplemental authorities letters, citing cases that were available at the time of briefing. Do not do this. That was the short version of what it said. And I remembered that. Again, it wasn't on the Fifth Circuit webpage when this happened. I was just so what do I do? So I said, but I need to bring it to their attention. I need to do it. So I'm I shouldn't file a 28J. I'm just going to bring it up. And not one of my finer strategic decisions. So I'm at argument. I start, talking about this case. And I remember now Chief Judge Elrod is center, Judge Higginson is to my right, or maybe to my left, whichever way. And they just start frantically looking at each other as I start citing this case. And go find this art. You can listen to me. You can listen to the audio of this. It's great. And they're just where was this in the brief? And you hear me say, it's not in the brief, Your Honor. When did you bring it to our attention? And I just start to try to explain that. I try to give that Weasley explanation that I just gave to you all, and they were having none of it. They just, were just you cannot do this. You need to, as soon as you find the case, you need to, you file the, it's not fair to your opposing counsel or to us to just do this. And I just, I tuck my tail between my legs and I just say, I'm very sorry, Your Honor, I won't do this again. Again, you can find this. And it's like there was some CLE that Judge Elrod did at the federal courthouse. I don't know, somebody asked her what not to do at oral argument. And I just blurted out. I just said, don't cite a case at oral argument for the first time. so that is, but it's, they were right, to their credit.
Yeah.
I mean, in the sense of, I don't know, there was no policy in place in the Fifth Circuit saying this, but more to the point, like, it's just the right thing to do. Like, if I'm going to bring it, if I'm going to cite some case, to bring it to the court's attention, the opposing counsel, as early as possible. It sucks out some of the poison of that. And so, as I always gear up for oral argument, I always pray, I'm like, I never want to be in that position, right?
Yeah,
Where I
right.
find a case that predated briefing that I wish I would have cited. But like my last argument that I did a few weeks ago, it happened. It just happened. Like when I was researching, I found one case and I'm like, it's on all fours. I need to get it to the court. And I just submitted a very short letter brief to the court. And I just said, while preparing for argument, I found this case. It's relevant to this issue. I plan to discuss it at argument. I wanted to provide it to the court and opposing counsel as soon as possible. It was less than a page. I didn't argue it at all. And that's that's my practice moving forward, for better or worse.
It's a good tip.
Well, I think that's very sensible. And unfortunately, we do have to learn some of those lessons the hard way, even though it wasn't your fault.
I don't know. I'm good taking the blame on it.
Hey, you got to take the bullet sometime. I totally understand. Andrew, this has been a great discussion. We appreciate the chance to talk with you and visit with you. And just thanks so much for spending the time with us.
Well, I really appreciate being on with you all. And I can't wait to listen to the next 5 years of episodes.
Thanks so much. We appreciate it.